Good afternoon, everybody. Okay. How many of you are new to the professional's office? Raise your hand. Very good. Very good. Wonderful. I'm Marilyn O'Neill. I am the risk manager and compliance director. So I'm available to you if you have these, earth-shattering questions that you don't know about certain things. You can always try and reach me by phone or by email. What we're going to do today, for those of you who are new,
How are you?
believe it or not, we do a lot of leases in our market area. And leases go very, very fast. They're not like listing a property for sale or having a buyer who wants to buy. And you need to always be prepared because there's so many areas within leases that you have to be pretty knowledgeable about from the very beginning. But a lot of times we get those phone calls and somebody says, do you do leases? And you say, absolutely. So you need to be prepared for those. And that's what today what we're going to do is talk about more from the perspective of landlord's representative, which is the lease listing agent. But what you're going to hear, it's great if you're a tenant agent because you're going to hear exactly what the landlord is obligated to do in many cases or what the responses should be from an appropriate landlord. But can we shut that door too? We get a lot of hallway noise. One of the things I always start out by talking about what has been the issue of the day kind of thing, or the week, for agents when I get the calls. And here's what I get a dozen times a week easily, maybe 20. Marilyn, I represent the seller and the buyers aren't closing on the closing day. Or Marilyn, I represent the buyers and the buyers can't close on the closing day. The lender needs a little more time or they need more time. And so a lot of times we get these questions, and as new agents, I just want you to understand the appropriate language you should use, okay? You should never say the contract is over. It is only over when the parties either close and fund or one party terminates. Do you see what I'm saying? And I had an agent who called me as I was on 99 getting here, and they said the contract's over, and I said, "That you don't get to make that decision." I wish we had that kind of power. I also wish people would pay attention when we advise them properly, they don't take our advice. And then they come to us and want us to answer and make everything better for them. But your language in the transaction is very exact, okay? And I'm worried sometimes we get caught up in saying things and we don't mean them in the literal sense. You just said it, something like that. But I never want you to ever state that the contract is over unless the parties have closed and funded, or if one party has provided notice of termination. Okay. And it's very, very important. And why is that? Well, these are legally binding contracts. The lease is a legally binding contract. And if the parties get into a really bad dispute, it's not the realtors that get to solve it, it's the courts. So we try and remove ourselves from making any statements where our client would take it and run with it and say, no, my agent said this contract's over. Or my agent said, I'm going to get the earnest money. Well, I'm going to tell you, you're never going to say that. Because the earnest money in any contract or the security deposit, what we'll talk about in leases, is subject to the agreement the parties have and what they're doing. So you can't make blanket statements like that, and I just want you to be aware of language, and the usage of the language is very, very critical. The other thing is third-party financing addendum. Remember how I said I'm going to bring this up until I don't get any more calls? We had a situation whereby an appraisal came back less than value. What that means is sales price is value, and the buyer's appraisal for their investor on the loan came back and it was less than what we had in sales price. Well, at that part, the lender is in control there. In paragraph B2 of the third party, it's very clear. If it doesn't meet underwriting approval, the lender is not going to approve the loan, and the buyer is entitled to the earnest money. Well, here's what happens a lot of times. We have sellers who get upset because they don't like that appraisal, because it didn't meet value, okay? And again, we're not charging the appraiser. Please don't interfere in the appraiser at all under the trade regulations. They don't like that at all. But here's what happened in this scenario. The property did not meet value. It was about $20,000 off. That's a significant number. And what happened is the seller kind of got upset and said, well, I'm going to order my own appraisal. Well, the seller can order 1 million appraisals. It has no bearing on what the lender's underwriter will do. If the lender's underwriter said, yes, I think we need a second opinion. Sometimes we've had them have 3 opinions. They got 3 appraisals out. But in this case, the seller was kind of driving this train. They were mad that it didn't meet value, so the sellers have an appraisal, and it now came almost all the way up to the sales price. Well, under the GSC in 2008, every appraiser who goes out, they have to have a contract. They have to know what the parties have agreed to. So the seller's position was, I'm going to find an appraiser who's more towards me. And what is the appraisal for? The appraisal is for the benefit of the investor of that loan. And a lot of times you think it's for the buyer's benefit, and it is, because the buyer wants it to meet value, because the investor then will approve that part of the property. But a lot of times it's not really what the buyers and sellers want, it's what that third party appraiser finds value. Is it about square footage? Only got 3 emails last week about square footage. So maybe we're doing a much better job talking about the buyers before they even enter into the contract. It is not about square footage. Believe it or not, the first time the buyer saw the property and the last time, it has the exact same square footage. It didn't change. And sometimes if you use it that way with your buyers when you're showing property, it's going to really drive it home to them. It is a number, and I understand that number is important. If that number is real important to your buyers, they're saying, I'm not going to pay more than $100 a square foot, you're going to put up a big stop sign and say, well, let me just tell you about the promulgated forms you're going to be required to use in the transaction. They're not about square footage. If you have an issue about square footage, you're told to independently verify. And that might mean that they would kind of escalate when the appraiser would go out, or they're going to hire somebody to independently an appraiser to come out and just measure. It just depends. It's going to be the buyer's choice. But you want to give them options. But our contract is not about square footage. It is about value. Paragraph 3 sales price. And so we have to do a really good job when we talk to our buyers and kind of run that through, because I'm going to tell you what is devastating for a buyer that signs and dates the seller's disclosure. You know, the law says a prospective purchaser has to have that disclosure prior to offer. Our contracts say, oh, if we don't get it prior to offer, the seller will provide it to you in so many days. The moment they get that, they have been deemed as to have been received. In other words, your buyer, even if they didn't sign and date it, it doesn't matter. You delivered it to them, and they know it. And right above where they sign, on the last page, in additional notices, the seller says, if you are using this square footage issue, you must independently verify. So it's real hard for a buyer to say, I didn't know that. Because every time a buyer signs something, they have been deemed what? To have read what they signed. Okay. They can get after us as agents and say, well, you didn't review it with me, and that might be true, but they can never say they didn't read it. That's on them. It's like Trek when they come back to the brokers and said, you're not knowing that your agents did that is not an excuse. It's almost like we're clairvoyant or psychic. We're supposed to know, and your broker's supposed to know everything you do at all times. And Trek says that is the worst thing when a broker says, this is the first I've heard of it when they get a complaint. And it might be. time it is the first time we've heard of it. The problem is, that's not a justification for not having agents do the right thing in behalf of the parties that they represent or settle their issues. But again, language is very important, and how we use it, many times the parties we represent take everything you say, and sometimes they misinterpret it. You might be meaning something here, and they don't understand it, so they're interpreting it differently. So many times we talk to them a lot, and in fact, we talk them to death. But we need to reach some kind of consensus, even with our own client, that they are clear on what this form that they're signing is about, what they're agreeing to, those kinds of things. So it's always very, very important for us to be real clear in our language skills. And when you're new, you don't know. I mean, I've been there. I think this is the most frustrating business in the world, where you get a license to practice real estate, and then you go, oh, I got the license. Now just tell me how to do this without getting into trouble or hurting anybody that I represent. Those are all common, and I'll just tell you that the statistics say that those agents that have been in the business 7 years or more are the ones that are the most litigated against. And it's because after you've done this a while, you don't go to training. You know what I'm saying? You don't attend certain meetings. You don't kind of stay connected about what has changed and those type of things. And I think my problem is that I had to balance production, lead generation, and staying in training. It's not an easy task what we go through, but we do a pretty good job trying to tell you when things have changed, when things are new. And what we're going to talk about today is more what Trek has told us have been very big issues with complaints regarding leases. And they'll talk about it in a tenancy standpoint. That means landlord or tenant, okay? And sometimes it'll be more landlord issue related, sometimes it'll be more tenant issue related. Next month we're going to talk more about tenant agents, because as I said earlier, that process is so fast that your head is spinning and you're thinking, I hope I reviewed everything with these tenants. Because here's the biggest problem you face, and some of us do as lease listing agents with landlords. They're going to call you when there's a problem, and you're not supposed to be involved at that point. Once that lease commences, your job is over. And it's really hard for us as agents to have really good clients, maybe a repeat landlord. You know, you've been leasing this property for a few years, and then come to you and expect you to give them a definitive answer about their duties under the lease. Can I do this? Should I do this? That kind of thing. And it's very hard. You're going to have to learn really good language skills, not to upset them, but to let them know that by law, you're not allowed to interfere in the lease that's between the landlord and tenant only. You can direct them back to their lease. You can know the lease so well, you can say paragraph 18 is about repairs. That's where you need to go. You know what I'm saying? Referencing something that they have in their possession that they're bound to is one thing. But to tell them, oh, the landlord has to do that, that's another. Okay? That's you making a decision about that. So what we're going to do is we're going to talk about the most frequently asked type of questions. Well, I would be remiss if I didn't tell you about the various documents that you have to have as a lease listing agent so that you keep compliance. Okay? I have to do that. Then we'll talk a little bit about the landlord, tenant, and rental criteria. And then I'm going to go online and take you to a place that you should put in your lease listing agreement that every landlord would use My Smart Vision. This brokerage firm has an addendum that says you're not going to run the credit report, you're not going to do the credit check, you're not going to verify with the previous landlord or anything that the prospective tenant might put on an application. So we want to tell these landlords where they need to go. Okay. To have a tenant. Not the language part. That might not be very kind. Don't know what Easter Monday. And then we'll talk about the frequently asked questions and some of the responses that Trek has given about certain things. Okay, everybody knows what the IABS is? Well, I am going to tell you that on here, and I didn't update it, which I needed to do. I thought I had it on this one. Along with the IABS, you can make right next to it a KWR notification. That has risen very high on my list. And while it's on your checklist that you're supposed to have that when you get your lease listing, I want those landlords to know you're not going to be exchanging any wiring information with the tenants, prospective tenants, tenant agents, or the landlord. Besides, there's places that we have it in the lease to do that. We have to have a lease listing agreement. If you are presented a lease listing that is not from the Texas Association of Realtors, you really need to get that verified before you agree to it, okay? Our forms through the association are slanted to help protect you and give you as much rights. And so if you get something from a third party that might be doing something, you just want to make sure that this is an acceptable kind of format that we have. The next one is the KW addendum. I mentioned that earlier because this office has a special addendum that the seller or the landlord will acknowledge. We don't do credit checks. We don't verify any of the information on the tenant's application. That's not our job. It doesn't, in the lease listing agreement, it doesn't say we're going to ever do that. There's a reason for that. That is more of what we would call a property management function. And you have to be working under a property management agreement. And you have to have permission from God to be a property manager. It's one of those professions that you have got to really know what you're doing. Because you'll be down at the courthouse more than you'd like if you don't know. Plus, your broker has to give you permission. It's a very difficult specialty area. And if you're interested in that, rethink that. That's the biggest, that's NAR statistics say that there is more claims on property management than anything else. And there's a reason for that. It's a very emotional kind of thing, and some property managers that I've known quite a few that have been associated with Keller Williams, and it takes all kinds of people to be really firm when they hear all these excuses of why rent wasn't paid. You know what I'm saying? And so they're very businesslike. They're not, they don't get involved in the emotions. It's just black and white to them. You didn't pay on time. Now this is the, you know what I'm saying? It's very different than what we do working for people in a transaction. Then the next thing is that landlord not only should know what they're doing, but they also need to know what is my criteria. And I have provided templates that landlords, you can give to a landlord and say, you need to modify this based upon what your requirements are. We don't make up the landlord-tenant criteria. And if you do make it up, you're going to be in trouble. Okay, because that's stepping out of what we do. The landlord really needs to agree to that. We've had some landlords who put things down and then the agent will receive it and go, you can't do that. That's a violation of fair housing. You know what I'm saying? It really helps you to make sure that at no time would it be perceived that there is a violation of fair housing. And most of the time, it's when you see it in writing, and this is what the landlord's requiring on something like that. CMA, do you think you should do a comparative market analysis? Yes. Every agent should do that when they represent a landlord, a seller, a buyer, even a tenant. You'll never go to jail because you did that. Because that's telling them from our MLS statistics, this is what I found. It's not that you said this is it, it's just what I have found. You pay really good money for MLS. You need to use it. And again, if I can give you any word of advice, new agents, the thing that frustrated me was I was supposed to know what a CMA was. And so you need to get into very good training so that you're able to look at the data that you have access to and know how to present it to your clients. okay? You will never stop learning. That goes on forever, for your entire career. I took more appraisal courses, not because I wanted to be an appraiser, even though the appraisers who taught the course kept saying, "Are you studying to be an apprentice?" I said, oh no, I said, I'm not gonna be an appraiser, but I need to know what you know. Because see, that gave me strength in understanding the data that was in our MLS. And so again, that's one thing that you really need. That's a way to do that when you're not really heavy into production, to really get into as many classes as you can to help you on stuff like that. The CMA is a price opinion. God bless you. It's not about that. We don't do that. You see, appraisers do that. We only do price opinion. So, again, it's very important to do that. We'll need the tax profile because we just want to make sure that you have a listing with the owner. And not some person that we can't recognize. Why are they there? And sometimes it comes down to, well, they just bought it last month, the tax, there's reasons for a lot of it, but we really want to make sure that it's the owner of record. Your CSS showing instructions, would you want to make sure that your landlord had that verification of it? Yes. Sometimes landlords have tenants in the property while you're trying to market a new prospective tenant. I'll think of you often. That is the most difficult position to be in. Because that landlord, that you have this listing agreement, they're going to continually try and put you communicating to their tenant. And you're going to have to find a really sweet way to say, I'm not doing that. I know too many realtors who've been in the business a long time that became really good friends with investors that had a lot of rental properties. And they were always pushed in the position of communicating to the tenant. Sometimes things that the landlord was supposed to do, not the lease listing agent. Our only communication with them would be rare. We already have the key box authorization that they're going to allow access to the property, and they've already communicated to the landlord, this is how we'll be able to show the property. You know what I'm saying? That's all taken care of. But you have a lot of problems when you let your guard down as an agent under this situation because you're good friends with the owners and landlords. And it has almost always resulted in a lawsuit against the agent or a track complaint. Because again, you were interfering. You don't belong there. It's not your lease. It's your landlord's lease. And I'll tell you, the more you have communication with them, an agent called me last week and they said, the landlord wanted me to do this and I went over and hand delivered it to the tenant and now they won't let me put my lockbox on. I said, that's not your job. Go back to the landlord. Make sure the landlord takes care of it. She said, yeah, then the tenant started telling me about all these things about the property. That's a kiss of death. Because now you have some information that could be true material. And if that new tenant didn't know about it, that you knew about, oh my Lord. That's what I'm saying. That's how it happens. You kind of let your guard down. You're just doing something nice. You're just sticking your sign in the yard when you have permission to do it. And they're going to try and pull you in. You're going to have to be strong here. Okay. I didn't say cruel, but strong. In other words, saying, know exactly where your lines have to be drawn. Oh, I really can't help you with it. That is a landlord issue. This is what my brokerage is going to require for me to go forward. Okay. And those agents that kind of don't do that, they do get pulled in, and sometimes it can be in a very bad position. The MLS printout. Well, here's the deal for lease listing agents, for any listing agent, for any buyer's agent. If you give it to your client and they say it looks great, they're the ones who know about their own property, right? As a buyer's agent or a tenant agent, when you give it to your tenant, you're going to say, this is what the listing agent has placed as far as the property goes, but you need to independently verify, okay? But as a lease listing agent, if that landlord saw your printout and they didn't bring to your attention anything, what did you relied upon them knowing it, right? So you see how the risk kind of transfers, takes from you, you're giving it to the landlord to verify that everything is correct. The agents that did that it kind of turned the tables on the individual landlord and sellers who were trying to blame the listing agent for not having, bought something. And we showed proof, no, we delivered it to you on this date, and your email said everything looks good. We don't live in these properties, and so we don't know. We're relying upon the party that we represent as a landlord or seller to tell us the truth about the condition of the property and that type of thing. And then introduction to My Smart Move. I put that on my list because I think it's very important. It takes you away from even having access to that confidential information. For those of you who weren't here last month, remember how I talked about cyber and how I'm concerned about it? Because it's not going away. We had another issue last week, and because we have been giving these notices out to our clients and evidently bringing awareness, the buyer picked up the phone and told the buyer agent, I got a notification to send the money to the title company. The agent goes, oh, no. That is not a communication. And I'm seeing now at the bottom of some of the email signatories for title companies, they're even putting it. We will never send wiring notice to you or request it. And and I'm saying that I like that because it's kind of helping us educate everybody a little bit more. But it was averted because the buyer was told, anytime you get that, don't respond to it. You pick up the phone and call me. Okay, that was it, and it saved a big issue. And so again, it's really important to make sure that they get those wire notifications so that they're aware that there is this element. It's not going away, they're just getting a little smarter on it. Yes?
Marilyn, I've got a situation where I've been listening a place, and now the people going, okay, maybe we also want to lease it. Okay. So I've got some of that information, but should I start a whole other document thing for leasing for you to look at?
You have to have your lease listing document submitted. You can't go off of what it is for sale.
Right.
Between the two don't mean.
Okay, so just create another document saying.
You're going to probably create another folder in that same loop.
Oh, in the same loop?
Yeah.
Okay.
Mainly because it's the same property.
Okay.
We have all these loops out there. Does everybody know what a loop is? They're dot loop. Oh, yeah. You'll learn a whole lot about loops that you don't really care to ever know, but you'll have to know it. And the interesting part is we can never delete them. We can archive them, and how many of you know what archiving is? There you go. Okay. That's another word you'll learn when you get into dot loop about archiving. I have more agents that archive the folder that they want reviewed, and they all say, how come you haven't reviewed this? And I go out there and manually find it, and it was archived. We'll never see archive. Archive kind of like disappears into a place, and it's not up on our dashboard, or we don't ever see it. But that poor little agent kept submitting it to you. And I thought, well, it was archived. So again, those are special words, right? Okay. I talked a little bit that as a lease listing agent, you're not a property manager. And if you work with a landlord who's new, you're really going to have to give them some places to go for tools in their little tool chest to do it. And you really have to be constantly forwarding them to Chapter 92 now. Well, I'm going to tell you that the Texas, have any of you heard of Texas A&M Real Estate Center? Yes. They have a huge document that nobody will ever read because there's a lot of pages, but it is on landlords and tenants. And it is a superb resource. And so what I'll do is I'll send it to Karen, the link and what the name is, for you to have it. So if you're working with a first-time landlord, you're going to send that document to them. And it's going to be like their continuing education. They need to take this class because it compresses everything, and I said, it went on for a bunch of pages, and I kept thinking, oh, nobody will ever read this. But it is a wonderful resource. It's one of their top resources that people download, and I think it's because they have to help educate their clients, both landlords and tenants, and that would be a good thing. Be very thorough on the listing agreement. When you have too many blanks on a lease listing agreement, you're gonna not have all the information that you need. And in case you understand what the lease gets filled in, the landlord has to state, this is what I'm gonna agree to on the lease. And it's in paragraph 20 of the lease listing agreement. So you can't have any blanks there, you know what I'm saying? Because that's what that landlord is gonna require that tenant to accept. A lot of those fields from information are on the landlord rental criteria as well. So it's like, that's where the landlord needs to make the decision, and now you just need to present that. I want you to kind of write down something that you're going to think about with landlords. Last week we had 3 issues on infestations. Now, I was asking them, were they rodent were they insect infestations? I wasn't sure because the agents were calling and they were saying the tenants are upset, and the landlord called me and said, do I have to do the treatment? The landlord thinks it's the way the tenant keeps the property. Here's what you're going to do to every landlord. Do you want to make the tenant pay for the service, or do you want to build in that service in your monthly rent? Okay? These are things landlords need to think about. The other thing I would say that if a landlord has a pool or some nice landscaping around the property, that they'll incorporate a firm to do all of those and have the tenant pay for it. In other words, it's bundled into their monthly rent. That's the best way to go. For you to receive a call from a landlord 4 months into a lease, should I, exterminate for the pest? That's not our job. Our job was to help that landlord evaluate how do you want to go about it. The tenant has to keep the property in a condition that will not be conducive, okay? But here's the thing, if your landlord says, I'm coming over at 2, do you think everybody's gonna make the property look like it's perfect? Yeah, that's usually what they do. If the landlord wants to have periodic inspections, which I personally think every landlord should do, they're gonna put that in the lease. They're gonna have that in the rental criteria. Landlord requires bi-monthly, whatever the landlord wants, inspections. And I'm going to tell you what happened. We did a little experiment with an agent who listened to Gary Keller. Do any of you know Gary Keller? And he was really pushing in the early 2000s for us to be real estate investors. Not only did we work for others, but he said, you need to invest in real estate. So we had an agent team that went out and they just said, well, we're going to do what Gary Keller said. So they started buying up rental properties. And the first couple of months out, every time a tenant left, they had to redo the whole house and fix it up. It was trash, all these kind of things. And they decided that putting it in the lease where the tenant knew the inspections will be on this date and this month, when that tenant left that property, they didn't have those issues. Isn't that great? It was just kind of like them figuring out, because they lost a lot of money trying to fix the properties back up. What happened, it wasn't every time, it wasn't the landlord that went out there. The landlord had hired somebody to go and change the air filters for the heating and air conditioning system. In other words, they employed different people to come and do the inspection. It wasn't just the landlord, okay? So again, kind of talk to your landlords about this. If they're experienced landlords, they understand this. But too many times we work with an investor and we sell them the property and we represented them as the buyer, and then they turn around and say, now I want you to list it for lease so that we can get a tenant in it. They're not going to be in that framework. I've done this before. This is what I'm looking at. So it's going to be your encouragement to kind of get them to make that decision. But if they're most of the time with a pool and spa, we have a special addendum, and in our lease we talk about landscaping and the cost of it and who's going to do that. My recommendation to a landlord is hire your own pest control company and your own landscape people, and then make it built in so that the tenant is not, having any influence on it, that the landlord's in control of those issues. And some homeowners associations are very, very strict on those things. And so a landlord could have all sorts of fines that the tenant will have to pay, and instead of dealing with that, if they did it right, it's not a good position. How many days does a landlord have to give the tenant a copy of the lease? It's by law now. See, these are the frequently asked questions, and we're going to get to them. There's lots of different questions that are constantly asked. And again, it's at the last page of the lease agreement. It's down at the very bottom. It is a warning because it is now a part of the law that the landlord has to agree to. Which conditions must the landlord repair regardless of what the lease may provide? We get asked those questions all the time. What do I have to repair? Your tenants usually ask you too, oh my gosh, what should I do? And here is the response. The landlord must make a diligent effort to repair or remedy any condition when the tenant has specified the condition in a notice to the person who collects rent or to the place where the rent is normally paid. It's in writing. The tenant is current in rent payments when the notice is given. And the condition materially affects the health or safety of an ordinary tenant or arises from the landlord's failure to provide and maintain in good operating condition a device to supply hot water of a minimum temperature of 120 degrees Fahrenheit. The notice must be in writing only if the written lease so requires. Our lease does require that. It should never be blank. Okay, never. As a practical matter, all notices should be in writing and either delivered in person or sent by certified mail, return receipt requested. When a tenant does that, can they show proof they did it? Yeah, that's what they're going to need if there's a dispute. And it should be delivered some verification such as a witness or written acknowledgement that the receipt of the notice has been provided. This has to happen each and every time, okay? And I love it. A tenant one time, the lease said you have to provide this notice in writing, okay, to the landlord. The landlord came to deliver some part that somebody was going to need to fix like in 2 days or something. The landlord was dropping it off to the tenant. And the tenant went, oh, by the way, this isn't working. Would a landlord have to pay to that, oh, by the way, notice? Absolutely not. See, that's the problem for these tenants. They have to know that their duty is to notify the landlord so that it can compel the landlord to make that repair if the repair is a part of the agreement in the lease. If the tenant caused the issue, and the landlord's going to find out, because if the landlord dispatches somebody, that third-party company is going to say, oh, the tenant caused this condition. The tenant will be obligated financially, all of it. We have that a lot in Houston. I don't know, but the weather's beautiful right now, but it's not going to be that way. And it's going to get really hot. And a lot of times when there's an old system, and a tenant's gone into a property, and maybe the landlord's just kind of patched it over and over, and it's not really working at the best condition level. A lot of times the tenants really put that thermostat down really low because they think that's going to cure the fact that it's not cooling. And unfortunately, that's where the tenant and landlord are going to get into a big dispute because the tenant caused the freezing of the system by putting that thermostat down. Little things like that, that's what the landlord is required to tell their tenants, okay? Because otherwise, the tenant is just trying to make it cooler in the property when it should be. Notice that it says, must make every diligent effort to repair or remedy any condition. Well, as a landlord, you better have that property in good condition when you put that tenant in. Okay, that's what your landlords need to know. And when a landlord is saying to the HVAC technician, just put that Freon in and just, patch it up and let's get it working, that doesn't mean it's always in good condition. And if, as a landlord, we're expected to have the tenant, what we call a normal tenant, an ordinary tenant. What that means is those tenants in that property are not subject to immune conditions or needing a perfect environment. They're just ordinary tenants. They're not tenants that are subject to any medical conditions that might not be the best match for the landlord and tenant. And so we'll talk a little bit about that when you represent tenants, because believe it or not, that tenant doesn't know the condition of the HVAC, nor do you as the tenant agent or as the listing agent do. No, that's not our duty. Our duty is to what? To market the property, secure a ready, willing, and able tenant. You're relying upon that landlord to have the property in good condition. That's what they're required to do. And what causes a lot of problems for landlords is the tenants are there when the HVAC technician comes out and they've been working on the system. And they talk, they're just like realtors, they talk too much. And they're gonna tell the tenant, oh no, I've been working on this system for 6 years trying to keep it in. They give all this ammunition and the tenant is like, we had one tenant do a video and send it to the landlord. And then the landlord calls us and says, how can I get rid of this tenant? That's not your job. We don't assist people in breaching a lease or a contract. And when I mean breach, I mean trying to get rid of somebody that has an actual lease. So again, as a lease listing agent, we don't know about the condition. We're relying upon the seller, the landlord, to actually have the property in good condition. If you go out and look at it and you don't think it is, what would your words of wisdom be to this landlord? Yeah, you say, you know what, I think in order for us to secure a tenant and you not have any issues, you might want to get the HVAC system checked out. You might want to service the HVAC. Personally, how many times a year should you probably have the HVAC system serviced? Twice a year. They usually do like a spring tune-up, and then they have a fall, getting ready because you're gonna put on the air conditioning more in the spring, and then you're gonna put the heat on. And so you think about it. Would that be kind of important for the landlord to have that built in too?
Yes.
Yeah. See, that's what really will help that landlord have a good property in good condition, is that kind of maintenance. I've learned all of this the very hard way. I relied upon what people said to be true, like sellers. And when you rely upon them thinking they're not going to lie to you, that's not the world we live in. It is really what we really need to independently kind of verify that. And there's lots of specials about tune-ups. There's nothing wrong with the tenant saying to the landlord, I want the property to have an HVAC technician certified and servicing clean prior to commencement. Is there anything wrong with that? Absolutely not. Then at least that tenant will know, because they have to get they're going to ask for the paid receipt, because now the tenant knows at least I got it serviced and they said everything's in good condition. Or it might say it's not in good condition, it needs this work done. Again, the most asked questions revolve around what are the repairs that you have to make. Unless the landlord agrees otherwise, which conditions might the landlord not repair? Okay? Unless the problem is caused by normal wear and tear. What is normal wear and tear? Well, there's a legal definition of it, and the court's going to usually use it if you get all the way to the court. The landlord's version of normal wear and tear is not the version of the tenant's. Okay? And what they really mean is that you're not going to do anything to the property other than use it as a tenant. If you use the property hard, that's not normal wear and tear. Things being thrown into the wall, gashes on trim, work, and it's just as a matter of understanding that it's normal wear and tear. And the landlord has no duty to repair conditions caused by the tenant or an occupant of an apartment, a member of the tenant's family that they invite in, or a tenant's guest or invitee in case they were all having a party. We had one time when they had a very large party and the landlord didn't provide approval for it. It's one thing to have a small gathering or a family gathering, but when you have an excess of people coming in that might put more than normal wear and tear on the property, it would probably be good for the landlord to grant that permission in writing. But again, we have a lot of things because that instance of that thermostat where the tenant would put it down and it would freeze it, the landlord was very nice the first time it happened, but the third time they weren't like that. So the other thing is, in the lease, it says that the tenant has to keep the property in good condition. You know, they have to keep it free of debris or anything that would cause issues. And again, as I said, I think that landlord inspecting the property every other month is a really good sign that they're going to kind of keep a watchful eye on it. And what it proves is that at least at those times when those inspections go on, especially when the landlord gives them a list, that property will be in really good conditions on those days, you know, because everybody's going to clean up before the landlord comes to inspect, or the property manager or their agent.
Can you go in anyway if you don't have service providers going in? You can be on the level of service.
There is a part in the lease about access. That's the part that if tenant agents really reviewed the lease with tenants, not one of them would agree to. Because it says that the landlord has access to the property anytime, or their agent. Now, personally, I don't want you to put yourselves in harm's way. If there's not approval for you to enter, you're not going in. I don't want to read about it, okay? And the landlord should be careful too. But that's really the access to the property. As I said, if the tenant really read the lease, the tenants who do read it or the agents who bring it to the tenant's attention, they go, can we have a 24-hour notice? Yeah. If the parties agree to that and they put it in special provisions, then that means that they're going to have to give permission. Now, if the tenant keeps evading the landlord, that won't work. They have to be responsive to the landlord. They can't not respond to them. But many times we have that added in special provisions because the tenant agent has reviewed it with the tenant and they go, look, I've got kids that, you know, are minor kids coming home from school. I can't have that situation. And that's usually what causes the issue about that. And it says, what is a reasonable time for making repairs in a residential tenancy? Well, they quote the Section 92, which is part of what that landlord and tenant booklet from TAMU is about, as well as the law. But it says that for 7 days, that's reasonable time to make the repairs. Okay? Unless there are other things. And part of the factors that can happen is that it's not a condition that is considered a health issue or a safety issue. Health and safety issues have to be taken care of immediately. Okay? But sometimes there are conditions where the landlord has been provided proper written notice, and the landlord's trying to set up and get people out there to do it, and this is the soonest that we can have them out there. For a landlord not to respond is negligent, okay? That's the thing. Once a tenant has provided the proper notice in writing to the landlord should respond. Yes, I got your notice, I've called the company, and I'll let you know when they're scheduled to do the repair, okay? And so again, there could be a delay of 7 days, and it could be because maybe they're waiting for a part on that type of thing. Sometimes we've had issues with appliances that are so old, like the cooktops and the ovens, that, you know, even a little dial that they are missing, they have to put on back order and try and secure one. So sometimes there are things that are delayed, but for the most part, the repair should be within 7 days. Otherwise, the landlord has to prove why is there a delay to the tenant.
Question.
Uh-huh.
I'm dealing with something similar to this that's actually the HOA. So my landlord needs to have the balcony fixed because it's a liability before we list it on MLS. And it's already been 2 weeks and they just aren't getting back to us. Are there any stipulations in HOA kind of doing the same thing?
Yeah, usually in the covenants and the restrictions, it says that they will have to respond. The HOA can't go sign on either.
Okay.
And sometimes, is it managed, is it an HOA management company? Yeah. The owner's really gonna have to get fierce with them.
Okay.
Yeah, you know what I'm saying, because that's their responsibility. That is, they're subject to that association, and the association must respond to the individuals. They can't just ignore all of that.
Thank you.
What is the definition of a security deposit? Have you ever had that? I did. Well, a security deposit is defined as an advance of money other than an application fee or deposit or advance of rent payment. And it's basically to secure the performance of the tenant, okay? And so the interesting part about it is there is no set in stone an amount that's truly negotiated between parties. That's part of that landlord rental criteria. The landlord's going to say, I require this as a security deposit. And again, it's only for the performance on that tenant basis. That's what that security deposit is for. We'll talk a little bit later about some other questions that always come up. But bottom line is what that means to a tenant is that the landlord's going to have these monies in any event that the tenant doesn't perform. They're in breach of the lease. The landlord has some remedies of how to account for that security deposit. And so that's really what it's meant to. It's strictly negotiable. When you visit with your landlords, what is typically what we see in security deposit?
1 month.
We typically see 1 month's rent. And it's not that a landlord couldn't ask for more. We have seen situations where a landlord will give their criteria and then a tenant agent calls, the listing agent, and says, I have a certain situation with these tenants. They would be willing to pay double the security deposit if your landlord will even consider their application. And that's not being discriminatory. The landlord's being presented, this is an option that this prospective tenant would like to present. In this town, we have a lot of advanced rental payments too. And landlords, they know this. They know that if your tenant gives 6 months rent up front and the tenant doesn't commence or they breach the lease, they're never going to ever see that rental payment. Because those are rents that are due for the lease. The landlord has the right to escalate all rental payments if a tenant breaches the lease. Most of the time we have more reasonable landlords, they'll say, well, I'll just account for it and then I'll try and relet it, that type of thing. But there's no tenant in the world that can ever think they're not going to owe this landlord the money. And they really can never breach the lease. That is deadly consequences for them. Long-term as well. Talk to a mortgage lender. See if their investors would think kindly of somebody who had breached a lease. Now, that's kind of a telltale sign of how they may respond with a mortgage. Okay. So it creates problems for a very, very long time. The next question is, when should a residential landlord return a security deposit? Okay, here's what I'm going to tell you. A year ago, you put that tenant in the property, right? You're thinking, great. And then you get a call. And you're thinking, why are they calling me now? And they're calling to see if you will help them get back their security deposit. And as I said earlier, that's one of those problem areas where you're not going to have anything to do with it. That's not your job. But you can tell them what you know, okay? And the landlord is required to return the tenant's security deposit on or before 30 days after the tenant surrenders the premises. There's a definition for surrender. And it usually means that the tenant gives not only their written forwarding address so that the landlord can account, because the address they have is his own property. So they have to have the forwarding address. And the surrender of property usually means that the landlord and tenant have met and the tenant has turned over all the access devices, the keys, any remotes, those types of things. In other words, they walk the property, the tenant has surrendered it, and it is done. But sometimes we have tenants that don't even give notice of surrender, okay? And it's interesting because even though we require per the law that the tenant has to provide the forwarding details, the tenant never, ever gives up the accounting of the security deposit, ever. They may be a little slow on giving them the forwarding address, but a landlord must always account for it within 30 days. Now, they may not have any place to send it, okay? But they are required to do that. And so that's why with landlords, sometimes landlords and tenants don't get along very well at the end of a lease. Sometimes. It's not all the time, but sometimes they don't. And as I said, I think we need to do a better job in educating our landlords what they should do when it's coming to the end of the lease and they know the tenant is not going to renew and the tenant has given their notice, I'm going to leave. That landlord at that point in time needs to set up a time. I need to meet with you to walk the property and for you to surrender the property. That's really what a good landlord should do. Property managers do that a lot. Lazy ones don't. They just say drop the keys off at the front desk with your forwarding address. But really good ones do. And you know why it's really important? When people are face to face with each other and they're walking through the property and they've got the move-in condition form from when the tenants went in. If the tenant didn't do the move-in condition form, what does the landlord have a right to say? The property was perfect. So that's why that move-in condition form is a part of that lease. It says within how many days the tenant will do that. If the tenant didn't do that, that will be a problem for them because the landlord can take it as being perfect property. And no property is perfect, okay? But that's one of the problems for a tenant is in the event that the landlord didn't receive that, because that's what is so critical about documenting what was the property like the day you took possession versus the day that you're surrendering it. But your landlords need to know they need to be active in that role. That's not your job. As I said, a lot of times when tenants are in the property and we're marketing it for another prospective tenant, they have pulled that lease listing agent and that landlord said, will you go over there and do the walkthrough with that tenant? And again, the agents that have done it extended themselves because they were trying to establish a really good relationship with this landlord, but it really put them in a really bad position because what if the property wasn't in the good condition? That listing agent would not know. That's not their job. And putting themselves physically there causes the dispute for them. But again, the landlord always has to account for the security deposit. That's not, I've heard landlords who say, well, they forfeited it because they didn't do this. No. Their duty as a landlord is to always account for it. That's part of the statute that they have to abide by. What charges may a landlord deduct from the security deposit? That's another one they always ask the agents. We're not property managers, but they always ask this question. Some may be deducted from the security deposit. And the basis of that usually is what that move-in condition form is that the landlord has and what the condition of the property is at the time of surrender. Normal wear and tear, they cannot charge a tenant for. Do you think normal wear and tear would include a dirty carpet? No. It could be. Excessive staining, ribs, no. But when you use carpeting and you walk on it for a year, is that not normal? Yeah, I would think so. And usually, That's part of all those fees that the landlord charges up front because they're gonna make sure that there's a cleaning fee, in other words, the landlord has to really do a much better job in thinking about the condition of their property under tenancy. So they really need to do a much better job. But they can deduct for certain charges, but they have to prove that the tenant caused the damage. And the only way I know that to happen, from a landlord's perspective, let's think of it this way, is that at the time prior to commencement that the landlord takes very good photos of their property. Don't you think that would be normal? All the good property managers that I know have got volumes of digital photos of the condition of the property prior to commencement. Their date and time stamped on it, and they've done everything. They go down, they take shots of baseboard. They take shots of the fixtures in every room, the condition of them. And so it helps, and from a property management perspective, you can see they're not going to remember. If they have 100 properties, they're not going to remember each one. So they want some type of digital record. That's what I recommend the landlords do. I'm going to recommend that the tenants do it too. And I love the tenants who, when they complete the move-in condition form, every area that they've identified that is not in good condition, they had a photograph of it. And that was on their move-in condition form. And that speaks volume because now the tenant is saying, I don't care what pictures you had from your agent to market the property. I'm talking about the true condition of the property. They're very different. They can't rely upon the photos that you take to market the property because those are going to look really nice, aren't they? And it's just not the same. So just remember that's a really good way that landlord will be able to verify this was the true condition. And when it's date and time stamped, right next to the commencement date, that's the best way for a landlord to be able to do that. Why is it important for a tenant to provide the landlord with a forwarding address after the lease ends? Well, as I said earlier, the landlord has to have that because they can't send all of the documentation that they need to send for the accounting of any fees that they might have, in particular the refunding of the security deposit. And until they receive that, they just are in a holding pattern. They can't send it out. They can't notify things like that. They have to give the tenant a written description of the damages and the charges. They can't make it up. Okay? There would have to be legitimate charges that a landlord had paid. Those were true what we call damages that the landlord had to pay. Okay? And so they have to have documentation. It can't be just, on their work or just say, well, a line item. They actually have to prove that they incurred that money paid to repair that damage. Okay, they cannot be made up. They truly have to be substantiated. And again, even though this tenant, when they left the property, didn't give a forwarding address, it doesn't mean that the landlord is not obligated to account for all of this. The best way for a landlord to know is to do it within those 30 days and just have it ready in the event that they did get the forwarding address from the tenant. In today, with the communication that we get a lot of calls sometimes from landlords or property managers that said, you put this tenant in there last year, we need to find out, do you know them? Do you know a way to get in touch with them? They're trying to pull you in when they should have done a much better job. Landlords, on their applications and their information on the lease, they should have ways to communicate with them other than a property address, because the property address that they're in. In case of there's several notices where in the event that something happens to the tenant, then this is the next of kin or the person that would be responsible for responding. Make sure none of those are ever blank. That's not good from a landlord perspective to have them blank at all, because you don't want to keep getting pulled into it. May a tenant use the security deposit to pay the last month's rent? Never. Rent is that part that, as I said, is they are obligated to. On the first day of commencement, they are obligated to 12 months or the term of the lease payment, period. No ifs, ands, or buts. They're going to pay that each and every time. And so a lot of times tenants agents will get calls from them and say, can I do this? And the tenant agent responds and says, oh yeah, that should be no problem. No. By law, they're not allowed to do that. Per the lease, they're not allowed to do that. So just don't give information out without, understanding what is required. If you gave out permission, say, yeah, you can do that, they're going to blame you. You know why I didn't send you that last month's rent? It's because my agent told me I didn't have to. And we're moving into a great new house, and that agent helped me. We've had 3 truck complaints last year, and here's what the situation was. The buyer agent was contacted. The tenant say, I'm under a lease now, but I want to go find a property, right? And the buyer agent was excited about having a client that needed to find a house. They should have said, what is the term of your lease? And what it proved in 2 of the 3 cases, the buyer agent really reviewed it with those buyers, the tenants. They had emails. And the tenant said to them, don't worry, I've already talked to my landlord, we have an arrangement. Now the arrangement wasn't in writing, which we all know should what? Always be. In the case of a lease, anything. It should have been where the landlord agreed. Okay? And these tenants were telling the buyer agent that the lease is up in March. The lease wasn't up until September. And they came from another state in the world, but I thought they were from another planet because they said, oh, our leases are only 6 months in this place. I'm thinking, no, it depends. You know what I'm saying? And they were thinking because the first lease they ever had in another state was only for 6 months, they were thinking their lease was for sometimes it's really hard to trust what they say. But if they were able to give you proof, no, this is my lease and these are the terms, and now the landlord is obligated by law to give a copy of the lease. So if the tenant says, I never got a lease, well, that landlord's going to be in trouble. But that tenant needs to secure a copy of that lease, even if the landlord didn't give it to them when they're supposed to, because that's what is going to guide that buyer agent from saying, I would love to do this, but unless you and the landlord reach an agreement in writing, you are obligated to this lease until this time. So don't assist somebody that is under a lease unless you really know what you're doing. Now, a tenant is prohibited from withholding any part of the last month's rent on grounds that the security deposit will cover the balance. If the tenant so withholds, the law presumes the tenant acted in bad faith. And there's a punishment when you act in bad faith. And this punishment happens to be 3 times the amount of the rent. That would be pretty punishing. That would make you feel really bad. So, and then they get to throw on attorney's fees and all this other stuff. But again, that's where we've had issues where agents have advised them, yeah, there should be no problem. The security deposit is the same amount as your last month's rent. Never. They are obligated every month to make that payment for that lease. No deviations from that. Is a landlord required to provide an itemization of charges he withholds from the security deposits? Yeah. He's prohibited from withholding any security deposit or failing to provide a written description and itemization of the deductions. And again, as I said, it can't be where the landlord just makes this up. There better be a paid invoice to follow up with that, okay? Some landlords hire handymen and women to do certain activities, but they better pay it and have a paid receipt, you know what I'm saying? Because otherwise, it's gonna be really hard for a landlord to say, oh, I just have them just go in and do that. That's not how it works. They really need to pay it. We have one that says, no, I paid him cash. That might not be the best way for a landlord to go. They just need to remember that. Mainly because the law dictates that to them, okay? And it says if the landlord wrongfully continues to do either or both for more than 30 days after the tenant surrenders the premises, the law presumes the landlord acted in bad faith. What do you think the tenant can do to a landlord that acts in bad faith? Anything they want. And the judge and the court will rule on that. There are tenant advocacy groups here in the Houston area. A lot of times when the agents get those calls 4 months into a lease and they're having trouble, that tenant they put in the lease is having trouble with the landlord. And I tell them, please don't engage in any more conversation about this. Refer them to a tenant advocacy group. There are tons of them in this town. And some of them are free. And some of them are church related. In other words, the church will set up that they have the members of the church that come in and volunteer their time. Sometimes they're lawyers, paralegals, and others that are used to doing this. I don't know of any property managers that volunteer to do that. But again, there is that kind of a group that can help tenants in the event that the landlord has not properly upheld the law about reporting all of the itemizations on anything that was removed from the security deposit. We've had more issues on landlords being upset about normal wear and tear. And it's funny because the TREC guideline says, normal wear and tear, well, that means it's going to mean whatever the court rules on. And as I said, the best basis for that is for a landlord to have a picture of the condition of the property and then the condition when the tenant surrenders the property. It's that same kind of thing. And you'll see property managers do that. The minute there's a surrender with a tenant, they go in and take photographs of it because they have to document and pay and itemize for that landlord so that they can report within 30 days of surrender. Property management is one of those areas that there is so much paperwork and compliance issues because they are the landlord. And that's a very burdensome type of responsibility. Do certain conditions have to be met before a landlord may charge a late fee? We get these questions all the time as lease listing agents because they're in the lease. And the lease listing in that paragraph 20, the landlord's supposed to complete all this, and this is when they ask you all these questions. Okay. A landlord may charge late fees for failing to pay rent on time only if the following 3 conditions are met. And it's the notice of the charge for the late fee is included in the written lease. Okay, and we have that provision in the lease. The fee is a reasonable estimate of uncertain damages that cannot be precisely calculated. You can tell that's a bunch of Google documents. And that came from TREC. Yeah. So what does that mean? Reasonable estimate. Well, in other words, they cannot pull a figure out of the cloud and say this is what it is. They would have to substantiate that. They can't just make a guess, a big wild guess. That results in the late payment by the tenant and the rent remains unpaid 1 full day after the date the rent is due. We get this question all the time. And our lease 15 years ago that the association provided didn't have this in there. And it is in there that it talks about 1 full day. So if the rent was due on the 1st, when would it be late? Depending on the contract. 1 full day after the date the rent is due. The rent is due on the 1st. Yeah, here you go. Does it care if it's a weekend? Does it care if it's a holiday? No. Does it care if the tenant's birthday? No. We got those. It's my birthday. Okay, well, you still have to pay it. The rent is due. Just because it's your birthday, it's not like it's a free day or something like that. But again, landlords a lot of times are, there are usury laws in the state of Texas. And what that means is that you cannot charge interest rate outside of the norm and all this. Well, that applies a lot to the landlord as well. They're not going to be able to just pull a figure out. It has to be reasonable. God bless you. And when landlords are new, they don't know, do they? No. And so they're always going to be looking to you to kind of answer all of those questions. And those are the kind of questions we don't have the ability to answer because we're not landlords, we're not property managers. Sometimes it might be the best thing if your landlord's asking you way too many questions and you're just trying to procure a ready, willing, and able tenant. You might want to recommend that they hire a property manager until they become proficient in doing it on their own. Last week I had a call from an agent and he said the property that this individual owns is a separate property prior to marriage. I said, okay. And she wants her husband to be the property manager. I said, well, she can appoint her husband to be a property manager. Yeah. Now, especially when he and she, God bless you, will share the same pockets. In other words, whatever benefits her is going to benefit him. Okay, even though that may have been her separate property. Where we have problems is when, as a lease listing agent, the investor says, I want it in my LLC. You know, in other words, they don't want their name as the landlord, they want the LLC. Well, the property legally has to be in the LLC. And we had agents for years and years that didn't follow what was appropriate. That's why that tax profile is so important, because if we see an individual's name or two individuals' names, they both have to be on the lease as the landlord. Okay? Unless they've appointed a property manager. But again, the LLC properties have to be in those LLCs for the LLC to be the manager of the properties. Yes.
What happens if people have property in their landlord too?
An agent has a property in their landlord. Well, the property, the owner of record is clear. It's either one individual or two, but they're both going to be on the list. All owners will be unless they've appointed a property manager. Do you have to be extra strict? Let me tell you what I tell everybody. If you are an agent, owner, landlord, and you list that property, we couldn't do anything to you like the law's going to do. Oh, they're going to pummel you. So I can't imagine, you know, and you should be very proficient, right? Because you represent others in transactions. You know real estate in and out. And yes, I know, and I get a lot of calls from agents that are managing their own property, and I said, I don't think you are proficient as a property manager. I understand you're the owner, and you're the landlord, but if you're asking me questions that you should know, that means you need some skill set to learn how to do that. Because it is highly litigious, and you'll never win. Agents and owners, agents who are owners never win. Never win, never win, never win. Because the law and the courts and the juries are all going to say, well, you should have known that. Why did you do that to that poor tenant? They're like that. I've had 3 judges in Harris County, one in Montgomery County and one in Fort Bend, who told me, if Keller Williams did nothing wrong and your agents did nothing wrong, the juries are always going to make you pay. That's why I don't like to be in the courtroom. You know? And I don't want you to be in the courtroom. And again, it's because it's that perception. But an agent owner landlord, whew, yeah, as I said, we couldn't do anything to you like the law will say. That's just a given. So you want to make sure you know exactly. And that link I'm going to send out to Karen, and she'll send it to you. It's 100-something pages. While I don't think you'll read it, you're probably going to give it to every tenant you represent and every landlord you represent, and prove that you delivered it. Yes,
And Marilyn, don't forget, we also have a property management company on site,
yes.
the Guardian Group, that will be more than happy to take care. So it's great for our agents to advise that, to say,
Absolutely.
you know what, matter of fact, I've got a property management that I can refer over to you.
Yes.
Yeah.
And as I said, when somebody says to you, I remember this when people would say, oh, I don't need an agent, I'm gonna represent myself. And as a listing agent, that's a scary thing. We have a lot of that happen with landlords and tenants. Because you've got a sign and they don't have an agent, they're gonna call the sign, they're gonna call you as the lease listing agent. And they're looking to you, they kind of understand that you work for the landlord and owner, but not really. They're gonna ask you way too many questions. And the same way with the landlord. When the landlord asks you way too many questions during the lease listing presentation, you're gonna know that, I think you need some help. And help that I can't give you, I can tell you to read things, but I'm not gonna interpret them and I'm not gonna be the property manager. And that is really good, to be able to have a resource that you can refer them to. And a lot of times that's just until the landlords understand, it's hard to learn how to be a landlord. And it's not easy. I'll tell you the example that is the worst thing is our buyers who allow sellers to stay in the property under a seller's temporary residential lease. They become landlords the day it closes and funds. Do you think a first-time home buyer could be a landlord and know how to account? And the same thing applies to them that I'm talking about now. They would have to account and itemize. They would have to be there when the prior sellers, now tenants, surrender the property. So just remember, even though it's a temporary lease, these same things apply to that first-time home buyer who just became a landlord because the sellers wanted to remain in the property as tenants after it closed and funded. Must the landlord provide a copy of the lease to a tenant? Remember how I started that out? Yeah. 3 business days after the lease is signed. It's on the last page of our lease down at the very bottom. A very seldomly used part of the lease because landlords have to acknowledge that they have given a copy of the lease. I can always tell when the leases are uploaded that the landlord hasn't done the job. As a lease listing agent, you will never ever allow that to ever be blown. You represent that landlord, you tell that landlord, you need to complete that bottom paragraph. And it says that the landlord has complied with the law and provided a copy, and it tells how they did it. We know you're going to do it. You're the lease listing agent. But you need it in writing with the landlord's initials on it, confirming it and filling it out. Don't leave that blank. Because the landlord is required, since the law went into effect, they're going to be held to big scrutiny on something like this. And that's like an Achilles heel where the tenant can just nip at that landlord. And who do you think the landlord's going to nip at if the tenant nips at it? You, the lease listing agent. Because we know the law changed. Our leases change every 2 years. The legislature is in session now. Oh yeah. And TAR is working on some things. And so every time our association, political action committee gets to work and they lobby for certain things to help us, they did a great job the last time. They diminished the power and authority to charge a transfer fee upon the sale of oil properties. You know how deadly that was going to be for our industry? They removed it permanently. So in the state of Texas, you're not going to, as a seller, you don't have to pay a 6% transfer fee. But it's not that way in all states. So our association does a really good job on some of these things. But the law changes, and the minute they put that law into place, there's going to be an effective date. It's usually January 1st. And if they've made one little change in the statute that affects landlords, we're going to have a new lease format. It took almost a year for tenant agents to realize that the wrong lease was used and the lease listing was. The effective date on those leases was January 1, 2016. We had a lease that came in from 2011. I don't know how anybody would have It doesn't even make any sense. And so just remember that you, as a lease listing agent, do you know what the landlord really wants on that lease? Yes, you do. It's in paragraph 20. Okay. Should you be the one that creates the template that you will share with the prospective tenant or the tenant agent? You think you should create the template for that lease? Absolutely. Otherwise, you're going to spend most of your time, once you get that lease from the prospective tenant, you're going to have to sit down with your lease listing agreement and go line item by line item for everything to verify that it is exactly what your landlord agreed to. If I was a lease listing agent, after the landlord has signed the leasing agreement, I would create a template, send it back to them, and say, please review this and make sure that we've added everything that we talked about and discussed. Because the worst thing for a tenant agent is to not have a lease listing agent who does that. Now the tenant agent and the tenant are sitting there making up, this is what I want to ask the landlord for. And then the tenant gets the response back from the landlord and it's all scratched up. No, we're not going to do this. Well, they knew they weren't going to do it from the very beginning. It's in the lease listing agreement. So as a lease listing agent, you really need to do a much better job. If you do that, you're not going to have these old leases that kind of sneak in, and you're not looking at the dates. And then you have your landlord and tenant in a lease that doesn't meet the requirements of the law. The landlord will come after you, and they have every right to. Yes?
So I'm a listing agent for a lease, and the rent is $1,500 a month for a property. And they have a $350 pet deposit, and it's a case-by-case basis. And they have, this tenant would have 2 dogs, and the landlord says, I want to raise the rent to $1,595 to accommodate that. How do you represent that?
Well, that would be at the time of application.
Yeah.
You put a notation in there that tenant agents must call first if any deviation of how many pets are allowed and what they want to do. Then the landlord could certainly do that.
But you don't have to, just put it as that's the rate based on that. Based on the, because in MLS it would say 1,500, but
right.
say 1,600 with the.
Right, but you've got a provision that the landlord says, I will deviate from this rent if this is the situation.
Yeah, so how do you represent that in a lease?
You probably, in a lease, you don't have to. In a lease, you're going to fill in the lease according to what the rental payment is.
Okay.
But you want to put in agent remarks that tenant agent needs to contact you first if the criteria. See, the landlord rental criteria states it. If the landlord says in that criteria, pets on a case-by-case basis, right then, if that tenant has pets, then they're going to have to review it. Can a landlord charge a pet deposit for a service animal? No, absolutely not. We've had agents who've gone down that road, and the landlord wasn't thinking clearly that that was a protected class. They're not really a pet. They call them a service animal for a reason. And we had never in our glorious history of millions of leases that we've done ever had a service animal that caused any damage. It's not the same for children and other pets. Mother-in-laws, aunts, uncles, you know what I'm saying? We just never have. They're unbelievable animals. Yes?
But Marilyn, if the criteria says no pets, are they discriminating if they refuse that?
Amen, they are discriminating, and you'll shut this operation down.
Okay.
We had a mega agent office up in our part of the world who represented a landlord who knew better. And the landlord says, I want a pet deposit. And that tenant turned them in. Man, they shut the doors. They all had to go to intensive training, and they couldn't do leases for a long, long time. Thank God they were not at the main office where there were 400 and 500 agents. Yeah, everybody was mandated. The landlord, I really was upset with him. He's a mortgage lender. He knows better. He knows firsthand all the laws. And so you cannot discriminate. These are not pets. As I said, pets cause damage, I know. I've had some, but not these service animals. As I said, we have never, ever had an instance where that has been done. And I'm gonna tell you, if there was any damage ever, who's responsible for all the damage? The tenant. It comes into place in the lease, period. And so the problem for a landlord is if they don't get enough security deposit to take care of all the damages, other than normal wear and tear, is that a wonderful event for a landlord? No. They're gonna be down at the courthouse, they're gonna make filings and have to petition the court and all. It is a very involved process. That's why you would want them to get in touch with the property manager, because it's gonna take a lot of their life if they've got a tenant situation like that, on something like that. May a landlord refuse to accept cash from a tenant? According to section 92.01, a landlord must accept the tenant's timely rent payment in cash unless in the written lease requires the tenant to pay by check, money order, or other traceable or negotiable instrument. So here's the big caveat. That landlord has to give a receipt immediately. Okay? So if he doesn't receive it because the written lease said cash was allowable, they have to enter the payment date and amount in a record book maintained by the landlord. They have to have written documents, even if it's paid in cash. Some landlords don't want that. I'll tell you where we have found a different process that landlords have used. They require it to be automatically deposited. Okay. We've had some issues with some banks. They will only allow a certain dollar amount. Chase Bank was the one that gave us the trouble. The lease had to accommodate for the fact that this bank would only allow the maximum dollar amount at one time. So they had to have in their lease modification that the landlord will get a payment on this date and this date in the various amounts to equal the total rent. Okay? So sometimes that's why if you are a landlord, you will want to make sure that bank that accepts it too won't turn it back. We had that. The landlord put their banking details where the tenant had automatically deposited, and it was too much and the bank refused it. These are crazy things that happen sometimes, but we're seeing that landlords are wanting to do that. And the reason they want it automatically deposited is, why do you think?
Faster.
Well, they can see. They can go in and verify it went today, or maybe we hit the second day, right? And when is it deemed late? Third. Right. So see, that's why landlords are doing that. I just want you to know that there are issues with some banks. Sometimes they're on the landlord side where they won't accept it, and sometimes it's on the tenant side where they're sending it and the tenant won't be able to send that large of an amount at one time. Okay, so you just have to kind of verify that because you don't want the parties to be blindsided by that. The cash payments, they can receive it, but they have to put it in a record book. That receipt is going to be a two-pronged type of thing. They're going to record it, and then they're going to give that receipt from that record book to that tenant that paid it in cash. Does the landlord have a duty to mitigate damages if the tenant abandons the lease early? This is another thing that we get all the time. Yes, for all leases, both residential and commercial, landlord has a duty to mitigate damages if the tenant abandons the lease premises before the lease term ends. Any lease provision that waives or exempts the landlord from this duty is void. So in other words, a landlord can't say, I'm not going to allow you, I'm not going to work really hard to try and get another tenant in the property and to stop these damages that I'm having because you failed to surrender the property, you abandoned the property, okay? So they built things into the law that help some tenants, okay? And the landlord has to know that. We had one landlord who said that they were going to sit on the lease for the remainder of the time, and I had to point out in the lease to the lease listing agent where the landlord's going to be in trouble if they do that. And that comes down to a landlord who doesn't know what they're doing. And they were looking to the lease listing agent to say, well, I'm just gonna sit on this and do it. And you know what, how this happens? We have had probably 9 out of 10 lease calls that I get is the day before the commencement of the lease, or maybe where the tenant is finally walking through the property. They may have asked the landlord to do some things prior to the commencement of the lease. You know, maybe clean the carpets or maybe clean it. And the next thing you know, the tenant goes with the tenant agent. They're going to the property and the tenant goes, oh no, I'm not going to accept the property. That is a horrendous problem because the tenant is obligated to take possession of that property within 5 days of the commencement, unless the parties have agreed to otherwise. In other words, you can extend it. What we have to do is usually use it's an amendment to the lease, but it's called extension of lease. And then you have to extend the commencement date. In other words, there's an issue. The landlord and tenant have agreed to extend the lease commence date because something is not right. The problem for landlords is if you as a lease listing agent and then the lease, the landlord agreed to do anything to the property, maybe have the HVAC service, you have got to be on top of it. There's no ifs, ands, or buts. You've got to get those receipts, make sure that they've done it. Don't leave it off to the landlord. It's the same way that you have to supervise repairs when you're under contract. As a lease listing agent, you have the same duty to help your landlord comply with the terms of the lease. Sometimes landlords are faced with this situation, and the lease listing agent is still involved because it hasn't commenced. The tenant goes in for their walkthrough, and they're very upset. They don't like all of this. And the landlord finally says, you know what? I made a wrong decision. I don't like these tenants. I want to let them go. Okay. Well, the problem for the landlord is the landlord owes Keller Williams the monies. And again, when is it earned? It's earned at time of execution. We usually get the first month's rent. If the first month's rent has been paid for the lease, we as the lease listing broker, we have to pay that other broker. We're not able to just say, okay, everybody gets to go away. So what has to usually happen is they're going to do early termination of the lease because the landlord doesn't want this tenant anywhere around, and then the other broker has to give their permission to release the compensation. Otherwise, the landlord will have to pay it. That usually means the tenant's first month's rent is used for it. And sometimes landlords just want to give it all back to the tenant, make them go away because they're scared. They're not going to be good tenants. But just don't fail to remember, leases are different. You know how we get an executed contract? Our commission is earned at time of execution, right? It's not payable to when it closes in funds. Well, in the lease, we usually require the monies for the lease, and it's usually, could be 1 month's rent. If the monies have been paid for the lease already, the landlord is obligated to pay the broker. And I don't want you to get caught that everybody went away and then the tenant agent said, where's my money? Because sometimes it is motivated by the tenant kind of wanting too much, and the landlord has made the decision, I want it over. Sometimes we have the tenant that is causing problems, and they say, I don't want the property, it's not the condition I thought it would be, and all these kinds of things. Just remember that while the parties are going to reach an agreement in writing to either terminate it, extend the commencement, whatever, that the commission issue is handled properly with the brokers. Because we do have an obligation that a lot of times landlords are not thinking about because they're thinking, well, if the tenant never moves in, I don't owe you anything. The other thing, can a landlord demand, say they put a tenant in the property and the tenant abandons and never pays rent the first month, second month rent is not paid. Can the landlord come back and ask for a reimbursement of all the commission? No. They can ask, but they're not gonna give it. And it's interesting, we've had this happen because it is earned at time of execution of lease, and all monies per the lease have been paid, okay? So, normally we have the landlords who allow us to instruct the other agent to have the tenant make out the first month's rent made payable to Keller Williams. Otherwise, the landlord had to give us a cashier's check at the time that they created the lease listing agreement with us. We're never ever going to go without making sure we get paid, because you have a duty and obligation to pay another broker if they're involved on something like that. Now, yes.
In the case of a double deposit, does the landlord have to explain why they're making the tenant, prospective tenant, pay a double deposit?
Yes, usually it's a part of negotiations. There's something that is turned up on the background check, or it could be where the landlord has contacted previous landlords. It could always be that. Those are those terms that are negotiated, as long as it's not discriminatory. And it would be discriminatory if nobody gave you a reason why. You know what I'm saying? Because we would assume, why would you be doing that? But many times, as I said, tenant agents kind of know. The landlord's given the criteria, and the tenant agent knows, this tenant doesn't have that credit score that the landlord's looking at, or this tenant doesn't have the work experience and being on the job for long enough. And believe it or not, we have a lot of divorces in this town. And what happens is one of those ex-spouses gets a lump sum settlement, and they've never been gainfully employed, but they have money. And see, some landlords want people to work, but some landlords think it's great that somebody has a bundle of cash and they're willing to pay 12 months up front. So you have lots of those kind of situations. Those are not discriminatory practices. Those come up because this is the situation. We had one where it involved, and I didn't put it on the slide, but we need to talk about this because landlords are held now by statute to a situation that could be construed of endangerment based upon the tenant they put into the property. When they do the criminal background check, they have to look at that very closely. If they're aware of certain situations, it is not discriminatory to say, I cannot enter into a lease with you, because their past has revealed that it could be a harm to others. In other words, those neighbors or whatever. That landlord will be in so much trouble if something happened that tenant did cause an issue. They will come back on the landlord. There is an obligation. That's not discriminatory. That's the landlord acting in their best behavior as far as trying to protect the public or the neighbors and that type of thing. And so we've had some issues where those individuals that have a background that would have normally reflected that the landlord would never have allowed to take tenancy, there were certain circumstances that the two parties had to reach an agreement on in order to go forward. But landlords have to be careful. They have to do the criminal background check. No ifs, ands, or buts. That has to be done. I remember the first time Keller Williams had to do that on all of the independent contractors. Because we had issues that came up, and this is going back a long time ago, about 15 years ago. And after that, it came down to all the operations. You have to do it on every agent. But do you know how hard it is when you've been with the company from the very beginning, and then they want you to go get, they have to run these checks on you, and you're going, I'm hoping. But again, but you never know about certain things. But what that came down to was, if the broker knew certain activities that the agent was involved in, TREC usually gives them a form, because you can't write a TREC on your application, and then TREC has the final say if they will grant you a license. If it's based upon these tenants, or we feel that at this point in time they've done their time and they paid for their crime, now they can be an agent again. But the landlord is in that same kind of situation. They have to be very careful Because if they're aware of something or failed to do that criminal background check, they will be in serious trouble if some incident happens, okay? I think they were trying to get that to look at domestic violence as well, because that usually does involve, other parties, the neighbors and those knowing and complaining about it. But again, those are some of the things that the landlord has to be very careful about. That My Smart Move is important because the tenant is going to be set up, the landlord's going to get everything, okay? The tenants go in, the tenants pay, they fill everything out, the landlord gets all the reports, and the landlord makes a decision. At what point do you think you were involved in that as the lease listing agent?
Just give them
Just give
There
them
you go. I set you up and get into My Smart Move, and I'm going to tell every prospective tenant to do it. That is the smartest thing to do. It's been wonderful. Because years ago, back before most of you were born, when we did these things, we had to call and verify the previous landlords, the employer. It was a nightmare. It was crazy that we would have to do that as agents. I don't think we were really equipped to do that. And I'm talking about in the early 90s. And so as time has progressed and as technology has progressed, they've given us a tool. The good part is, I don't like all that information on an application is dead. If you have it in your possession and something happens to that information, it's over for you, okay? If you've been hacked, your computer was stolen, whatever it is. And so, as many ways as you can to distance yourself from having any private information, especially as damaging as on a residential lease application in your possession, the better it is for you on something like that. Well, did y'all learn a lot about all these things?
Yes.
There you go. Yes?
So I started a couple lease applications, and this agent, you're just looking at the lease applications, he just denied one of them because he said a misdemeanor about 9-10 years ago, but he didn't actually run the application. And he just said, I just want to say your time and money, so they'll have to dump off the check, and we just want their backgrounds. Can you do that without actually?
A landlord can. Yeah. Now, I don't like the fact that the lease listing agent did that unless they were the property manager. If they're the property manager, they are the landlord. Okay. And they can have that criteria.
And we try to counter that same thing with people who know the double deposit, but they just never.
Right. And a landlord's not obligated to that. Now, he would be discriminatory if the next person who made an application had a really long rap sheet and he leased to him. Then you would be saying, you didn't use the same criteria to all the tenants. You were on 31 tenants. Yes?
Are they doing anything to mandate the amount of the application fee? They seem to be all over the map. They go from so low to so high.
Right. Well, here's what I am going to say. Whatever the fee is charged through My Smart Move, there would better not be any price deviation. I don't like it when we had it going on in the Heights. It was horrendous. About 5 years ago, we had one broker who collected 20 application fees for one property. It was a racket. It was, and we really did. We turned them in. We did because we do the right thing. The reason we did it is because 5 of the operations I was working with had tenants who were in that same boat. They were all trying to get the same property. And that's when I said, wait a minute, that address sounds familiar. You know how you hear it over and over? And so we just literally, that was a horrible scam going on. But the problem for a landlord is they could not charge a fee that would not be reasonable. And if the lease listing agent is acting about clearing it, doing the background check, processing it, doing all that, they don't have that in the lease listing agreement. That's not part of the duties that you are obligated to a landlord. That's a landlord's job. So I would have a really hard time with an agent saying the fee is going to be $95 when all the landlord had to pay for was $25, $30.
So what happens to the difference?
Well, that's the thing. The landlord and the lease listing broker may have an agreement if that broker is doing other aspects that are not standard in our lease listing agreement. But it just sounds like it's a racket to me. And again, as I said, we had that issue, and it was devastating because after a while, we started realizing that they did this every time. They were getting lots of money and taking application fees, but never even ran the application. Yes.
Yeah, in this case, I have a client of the tenant. We give the listing, the agent that the $80 for 2 adults for application fees. And she
Yeah,
said,
you have to pay it per individual,
Per adult,
18 years
yes.
and older.
yeah, $40 each adult. And she said that this is not refundable,
Correct.
correct? It's for the background check that go to my smart move. So
Same thing.
same thing. So that is not refundable.
Oh, no.
Oh,
None of those application fees are ever refunded.
okay.
But are you saying they use my smart moves and you had to pay them the $80? They did
No.
both?
No, it's just $80 to the leasing agent. They will.
So they didn't use my smart moves?
They asked my tenant to use this as my smart move, and she said that my tenant didn't give the authorization for my smart move because they need to get the authorization.
Yeah, you get an invitation, they have to accept it.
And my tenant say I cannot log in to my smart move, and just she done nothing about this one.
Well, that's what I'm saying. See, some of them make you pay an application fee, and then the tenant still has to go on and pay money to my smart moves. And that's what
I
I'm
would
saying. So
not
what do
think
we
that
do
would
with
be
that?
normal and customary, you know what I'm
Right.
saying? That's
It's
not
not.
reasonable to me. The application fee would have to have been on the landlord rental criteria and how it was gonna happen. You really wanna make sure your tenant has all of that before they make applications. Because they have to accept that, because the minute they send the application over the fee, it's done. Now, I am gonna tell you, if the landlord declines, and this is what's deadly for a landlord, if the landlord declines the application and they have not provided the landlord rental criteria, they have to refund that application. But that's the only instance they have to refund it. So if you as a tenant agent fail to ask the landlord for the rental criteria, that's your job as a tenant agent. If the landlord says they don't have any, now, if they're turned down for something the landlord knew, it's kind of like what happens when the tenants present a lease and the landlord scratches through it and says, no, I never agreed to that. They do have to refund the application fee if it was not provided to them prior to application and it's in writing. Most listing agents tell me it's in MLS. The tenant agent didn't read it. So remember, you are obligated to look at everything on that MLS and make sure that the tenant is aware of those kinds of things. Because they've given some mechanism to provide some of that information on the MLS listing about what the landlord requires. Yes?
I have a question regarding the example you used earlier about the tenant with the air conditioning problem, where they were like lowering the thing. So you said this happened like multiple times, right? So the first time the landlord was lenient with it, and then the second time they did the same thing again, and the tenant's fault that they messed up the system because they froze it. But wouldn't the landlord have been responsible after so the tenant did it the first time, they messed it up, and the tenant was responsible for that issue. But at that point, the landlord would be able to see that there's a problem with the air conditioning because obviously the tenant is having to lower it so much because the air is not cooling. So wouldn't the landlord at that point be responsible for doing something to the AC to make it work so that?
Well, what happened on the second time that they went out? The technician, the HVAC technician, explained to the tenant, you cannot do this because on this system, it will cause that. You have to do this and the settings need to be here. Okay, so the technician provided all of that to the tenant in writing. When the third call came in, that same technician went out because the landlords use the same vendors. And when that technician went out, the technician called the landlord and said they did exactly what we told them not to do again.
Okay, so there wasn't actually anything wrong with the AC.
No, they had fixed the AC.
Oh, okay, that was my.
This was the problem. As I said, the landlord is obligated to have everything in working order. Don't ever let a landlord think that's not the case. Okay, because that's a problem for them. And I'll be honest, most of the landlords where we have these issues with HVAC, and we're getting into the season, and we have them, they run almost nonstop from it seems like Memorial Day is the hottest day on earth here. And it runs for like 4 months, and we have all these rash of issues. Patching the system and just putting it back together, or just putting it on its last leg, the landlord needs to be very careful about doing that. And that's one of the reasons I really like the idea where a landlord has it checked, it's under contract, or at least seasonable, that they get these people out on the various times. And what's great about the HVAC technicians that go out, and the tenants are usually there, they provide a copy of what they did to the tenant. And then the landlord will get a copy as well. So it kind of proves what they did, advising the tenant and that kind of thing, making sure filters were changed and stuff like that. Now next month, we're gonna do it from a different perspective. Well, today, all the answers about the landlord help the tenant. Next month, we're really gonna go into more of the questions that, what do tenants need to do before they really get into a property? And it's going to be a little different than what you're normally used to. They have raised the bar in our lease by adding language that the tenant says they've inspected the property and accepted. So we're going to go through those paragraphs in the lease that cause problems for the tenants and what you need to cover with the tenants and what you need to recommend that they do. And what you're going to do if you work with, some agents don't work with tenants at all. But for those agents that do, you're going to have your list of the tenants' dues, what they need to do prior to going into a lease. You're going to have your little sheet that you're going to have signed by them and a part of your buyer-tenant agreement. So now it's going to show you recommended that they do all of these things. And the last part on that, I would love to say, don't call me after the lease commences. But again, as I said, something that's kind of like being proactive from that perspective, but have it in writing for that tenant to acknowledge. Yes, sir?
Is there a copy of that list you just talked about, what the tenants should do before going into the lease?
The thing about the landlord and tenants from Texas A&M,
Is that what that is?
there's a big, huge thing. It's 100-some pages. I'm going to use parts of it when I come and do the training next few times. Yeah, but you'll be able to formulate what you want to present to your prospective tenants that you're going to represent. But we're going to give you the baseline of what you really need to make sure you do cover. And then you can add as much as you want to. Yes, ma'am?
So yeah, got this, can we have this and this possible before your next course?
No, I will send a link to Karen to give you the thing from Texas A&M, but my training won't be until next month.
I'm working with my tenant now.
I know. All right, good people, y'all be safe.